India Legal presents Courts Roundup.
I am Tanya Chugh and you are watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here are the headlines. Supreme Court issues notice in plea seeking quashing of prerequisite of 3 years practice as advocate for being eligible for civil judge exam. Punjab and Haryana High Court holds that life and liberty of a living couple has to be protected even if one of the partners has not attained marriageable age. Bhima Koregaon case accused Sudha Bharadwaj files application for withdrawal of allegations made against her by the National Investigation Agency. Calcutta High Court directs Centre to open more CFSL Centres in the state for faster forensic examination during criminal investigations.
India Legal presents Courts Roundup.
The Supreme Court has sought the response of Andhra Pradesh government in a petition challenging the precondition of 3 years of practice as an advocate to be eligible to write the civil judge exam in the state. A vacation bench of Justices Indira Banerjee and Anirudh Bose issued notice to the state government but refused to stay Rule 52A1 of the Andhra Pradesh State Judicial Service Rules of 2007, which lays down the above condition. The petition filed by Regalagada Venkatesh also sought quashing of a December 2020 notification inviting applications for appointment of civil judge in AP. During today's hearing, the court asked the petitioner what the urgency to approach the vacation bench of Supreme Court was. The petitioner's counsel replied that the last date for filing online applications is January 2. The court declined to pass any interim order while issuing notice. The order states the petitioner has challenged a notification of 2020 inviting application for appointment of civil judge junior division in Andhra Pradesh State Judicial Services. Question is on eligibility requirement of 3 years as practicing advocate. 2007 rules are under challenge in this plea. There can be no kind of urgency to entertain this petition in vacations. Let the plea be listed for hearing on the date of reopening. Notice be issued in the meanwhile. On a plea by Anil Ambani's Reliance Communication Limited and Reliance Telecom Limited against the declaration of their accounts in the Union Bank of India and the Indian Overseas Bank as fraudulent, the Delhi High Court has ordered the banks to maintain status quo until the next date of hearing. However, the court has said that the centre through its investigating agencies will be free to take any steps or investigate or file any complaint proceedings against the two companies independent of the order, which declares the account as fraud accounts. The court said that the issues raised by the petition are similar to those raised by a batch of writ petitions. The court has also said that the banks are free to issue a show cause notice to the companies and thereafter give a necessary hearing in the matter. While action against RCom has been reportedly taken by SBI, UBI and IOB, RTL, which is a fully owned subsidiary of RCom, has been placed under the radar by SBI and UBI. The woes of Anil Ambani's group of companies have been ongoing for a while now, with another subsidiary, Reliance Infratel, undergoing insolvency proceedings and also being marked as fraudulent. The Supreme Court in September had dismissed SBI's appeal against the Delhi High Court order. However, the government is resolute upon allowing invocation of the personal guarantee and plans to challenge Ambani's stand as per sources. The Supreme Court Bar Association is preparing to hold its annual elections through a virtual platform owing to the COVID-19 pandemic. The Election Committee of the SCBA has suggested that the election should be held virtually using the NSDL platform. The annual polls elect the office bearers of the Executive Committee of the SCBA, which governs the top court bar. The Election Committee has considered the following for options to hold the elections: a physical election. An election in both modes, namely physical and virtual, will be made available to the voters as per their preference. The entire election be held virtually using a platform like NSDL. The entire election be held virtually on NSDL, but with a limited number of computers being made available in the Supreme Court premises for the convenience of those who may not have access to computer or phone. The options involving physical voting were rejected, taking into account the fact that the process of counting physical votes requires a large number of volunteers and agents of candidates. The option of providing limited number of computers for the convenience of those who do not have access to phones and computers, and was also rejected for the reason that it would require physical presence of voters at the Supreme Court besides support staff. Taking into account the COVID-19 situation, the committee has opted for the third option. The Election Committee of the SCBA has said that as far as the third option is concerned, the committee has interacted with NSDL and has found that it offers a foolproof method of holding the election virtually in completely safe manner. In an order of significant import, the Punjab and Haryana High Court held that life and liberty of live-in couple has to be protected even if one of the partners has not attained marriageable age.
Punjab and Haryana High Court has given an important order related to live-in couple. A single-judge bench of Justice Alka Sareen therefore remarked that the society cannot determine how an individual should live her or his life, especially when the individuals were major. Since the right to choose a partner is a fact of the right to life, the life and liberty of a live-in couple should be protected, Justice Sareen ruled. The court was hearing a petition filed by a couple who alleged that they were being harassed and threatened by the woman's family on account of the relationship. The two intended to marry each other but chose to be in live-in relationship since the man had not yet attained the minimum marriageable age. The two were, however, majors. The High Court placed reliance on Supreme Court judgment on Shafin Jahan versus Asokan KM, popularly known as Hadia case, to underscore that every individual has been guaranteed the right to life under the Constitution, with the choice of a partner being an important facet of the same. Therefore, there were no legally justifiable reasons for the family and relatives of a live-in couple to object to their relationship, the High Court concluded. Though the court refrained from remarking on merits or the legal validity of the relationship between the petitioners, it directed the police to take necessary steps and consider the couple's representation for security. The non-attainment of the minimum marriageable age was not an impediment to seek protection of life and liberty, the court reasoned, especially since they were both major. The court also made it clear that parents could not dictate terms in their adult children on how to conduct their life, and that individuals were entitled to live as they chose provided they did so within the contours of the law. Court said that parents cannot compel a child to live a life on their terms. Every adult individual has a right to live his or her life as she or he deems fit. The court, however, emphasized that it had not adjudged on the legal validity of the relationship in question. On these terms, the petition was disposed. Bureau Report.
The petitioner and detainee Parvez Ahmed Kuche moved to Jammu Kashmir High Court through his brother Wasim Ahmed Kuche, challenging the detention order passed against him by the district magistrate Shopian. The petitioner submitted that the order was passed without the application of mind by the detaining authority because the order of detention passed against the detainee from acting him in any manner prejudicial to the security of state or country whereas the grounds of detention contended that the acts of detainee are highly prejudicial to the maintenance of the public order. The court referred to the judgment of Supreme Court in case of G.M. Shah versus State of J&K 1980, wherein it was held that expressions, law and order, public order and security of the state are distinct concepts, though not always separate. The court noted, in the present case, intriguingly, detaining authority has made use of both expressions prejudicial to security of the state as well prejudicial to the maintenance of public order. The detention order passed for twin activity and depicts non-application of mind on part of detaining authority. Respondents have not replied to ground 5 in their objections or counter. The court held, thus, the reliance on both the basis and the grounds of detention furnished to detainee is to be held illegal, 1, and as corollary thereof impugned order is vitiated. The court quashed the detention order passed by the district magistrate Shopian and directed to release the detainee forthwith, provided he is not required in any other case. The Jammu and Kashmir High Court has upheld the decision to cancel liquor vend licenses while stating that excise policies were framed from time to time in the most arbitrary and irrational manner, just to benefit those who had access to the corridors of power and without any focus on revenue generation. A division bench of Acting Chief Justice Rajesh Bindal and Justice Sanjay Dhar passed directions for framing of new excise policy for 2021-22, strictly in accordance with the Jammu and Kashmir Excise Act and the law laid down by the Supreme Court on the subject. The court directed that the liquor vends already operating shall be allowed to continue till March 31, 2021, and thereafter the license shall be allotted in terms of the excise policy to be notified by the government. The government shall be at liberty to take appropriate steps in view of striking down of the provisions of the excise policies, which envisage grant an automatic renewal of licenses for a period of 5 years. The court has also held that renewal of licenses for trade in liquor is not a matter of right, which can be enforced. For the purpose of renewal of licenses for trade in liquor, if permissible in law, all the conditions applicable for grant of new license shall also be applicable, the court said. The court was hearing the batch of pleas against the show cause notices issued to the appellants for cancellation of their temporary licenses. The court called it a connivance of the government to allow them to operate despite the orders of the court. Welcome back. You are watching Courts Roundup. Moving on to the next story, the Calcutta High Court has directed the central government to open more CFSL centres in the state for expeditious forensic examination during criminal investigations. The court also expressed the need for setting up of exclusive DNA outlets. These directions were given by the court while hearing a writ petition filed by Rebecca Begum, who claimed that her missing husband was in fact arrested. She claimed that she did not know where her husband was being detained. The concerned inspector in charge had subsequently, on December 22, filed a report in the court stating that they had found skeletal remains of a man and same had been sent to CFSL for testing. At this juncture, the court was constrained to take note of debilitated state of the CFSL centres. The bench noted that in several matters reports sought from the local CFSL remain outstanding for months together. The Additional Solicitor General, who was present in this hearing, submitted before the court that steps had been taken by the union government to fill all the sanctioned posts of the CFSL. It was further positioned by Additional Solicitor General that union government had also employed more people in the CFSL on a contractual basis for speedier testing. The bench remarked that these steps were not enough to improve the conditions of the CFSL, and it opined that more testing centres need to be opened with more permanent sanctioned posts to come up with speed with the impending need. Bhima Koregaon case accused Sudha Bharadwaj has filed an application in the special NIA court at Mumbai praying for the withdrawal of the allegations made against her in reply filed by the National Investigation Agency. Bharadwaj filed the application seeking an order reprimanding the NIA and Special Public Prosecutor Prakash Shetty for their irresponsible conduct in making statements against her. She has also sought an order restraining them from making similar statements in the future. She has further prayed for a direction to the NIA to withdraw the allegations made against her and expunge the defamatory statements made on record. Bharadwaj claimed that the reply filed by NIA, signed by the investigation officer and special public prosecutor, was defamatory and contained baseless allegations. The reply filed by the NIA read, "It is pertinent to observe that by way of this present application, the accused Sudha Bharadwaj is digging the identities of aforesaid witnesses so as to cause harm to them." Bharadwaj stated that as an under trial prisoner, there was presumption of innocence in her favour and that the NIA's statements were not backed by proof and couldn't cause harm to the witnesses. She stated that the court should not be reduced to forum of gossip and slander under the guise of legal arguments. Bharadwaj concluded her application by pointing out that the prosecution cannot be allowed to level such defamatory and scurrilous allegations against her merely because she is accused of crime. Earlier today, the special NIA court directed the NIA to provide copies of the unredacted statements of the witnesses to Bharadwaj. The Allahabad High Court has granted anticipatory bail to advocate Arpit Bisht, who was allegedly involved in a case of assault upon a policeman with 6 other persons and snatching of his gun while he went for investigation of a case in ICICI Bank, Sector 18, Noida. The court has sought the response of government and directed it to file counter affidavit within 3 weeks. The court put up this matter for hearing on 21st January 2021 and directed to release the petitioner on interim anticipatory bail till then in the event of his arrest. In case of his arrest, the applicant Arpit Bisht shall be enlarged on interim anticipatory bail in the case. The applicant shall make himself available for interrogation by the police officer as and when required. The applicant shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade from disclosing such facts to the court or to any police officer. The applicant shall not leave India without the previous permission of the court, and if he has passport, the same shall be deposited by him before the SSP or SP concerned. Counsel for the applicant has submitted that the applicant was not named in the FIR. He is a practicing advocate enrolled at Delhi Bar Council. He went to the spot only on receiving the phone call of one Sarthak Tyagi, who is his friend, and after the situation got out of control, he left the place in a car with his friend. He had no role in the incident and has been falsely implicated in this case. The National Green Tribunal has refused to close the Oversight Committee and extended its term for 6 months and directed the state of Uttar Pradesh to put forward its suggestion while hearing the matter pertaining to monitor the pollution of river Ganga and sand mining activities around other rivers in the state. The Oversight Committee is constituted on the suggestion of the state of UP by tribunal for a period of 6 months, which was subsequently extended at different intervals. The basic functions of this committee are to monitor pollution river Ganga, rejuvenation of river Hindon and associated issues, sand mining at Allahabad, pollution of thermal power stations in Singrauli, pollution of Ramgarh Lake and river Ami in Gorakhpur, solid and biomedical waste management norms, etc. A bench headed by NGT chairperson Justice Adarsh Kumar Goyal has further requested the committee to monitor compliance of directions to oversee preparation of district environment management plans and their execution by the district environment committees. On the basis of recommendation made by the OC, NGT has directed the district magistrate Prayagraj to take further steps in the matter and maintain surveillance. The issue of compensation, if not already finalized, may be finalized with the assistance of CPCB, and the report should be furnished to the Oversight Committee. The National Company Law Tribunal Principal Bench has passed an order directing a resolution professional to not proceed a resolution plan in a corporate insolvency resolution process after an issue with respect to rights of landowners came up before it. The order was passed by 2-member bench of Acting President BSV Prakash Kumar and Technical Member Hemant Kumar Singh. Under the terms of collaboration agreement, the corporate debtor was to develop the land at its own cost and expense, including the expenses for obtaining the requisite approvals, licenses, etc. In lieu of the consideration the land, the corporate debtor agreed to provide certain sum of money to build a permissible constructed area and hand over the same to the landowners under the terms of the collaboration agreement. However, the collaboration agreement was vitiated by efflux of time as the corporate debtor did not perform the obligations. Thereafter, the landowners filed civil suits before the district court against the corporate debtor. Meanwhile, the NCLT admitted the insolvency petition against the corporate debtor. Certain landowners thus moved the NCLT asserting that corporate debtor was unlawfully trying to proceed with invitation of resolution plans in respect of their land. The landowner stated that the application was not maintainable in the eyes of law as the RP could not ask a creditor to file a claim in a particular class. The National Consumer Disputes Redressal Commission has ruled that when there is a doubt over the admissibility of an insurance claim, the benefit of doubt should be given to the insured. The order was passed by member Anup K. Thakur while dealing with an insurance claim in relation to a vessel that sank on its way to Sharjah. The owner of the vessel, the complainant, had moved the NCDRC after the insurance claim was repudiated by the insurance company, Oriental Insurance. Relying on the report submitted by its investigator, the OP argued that it was a case of poorly maintained vessel which suffered vibrations over a period of time and ultimately resulted in a breach in the hull. OP's claim was rebutted by the complainant on the ground that vessel, when it set sail, was seaworthy and was certified to be so by the authorities. As per OP's investigator's opinion, an unidentified object could not have been the cause of the accident. The investigator, relying upon cash invoices for maintenance, stated that vessel was poorly maintained. In view of the arguments made by the parties and the reports before it, the NCDRC concluded that it did not agree with the opinion of the OP's investigator. The NCRDC observed that the vessel had all the documents necessary for sailing and there was no reason to believe that it was not seaworthy at the time of sail. In view of the interest of the insurance amount, the NCDRC stated that there could not be a separate award towards mental agony and loss of business. It nonetheless awarded cost of Rs 50,000 to the complainant. That's all for Courts Roundup. Thank you for tuning in. Keep watching APN.
India Legal presents Courts Roundup.